Sure.
Is your time on to
You guys want to
yeah.
go?
You can have a seat. Right, remember you're still under oath, okay?
Yes, sir.
You may want to pull the microphone down, make sure everybody can hear you. Remember that wait for the questions to be asked before you respond.
Yes, sir.
Court reporter still taking your records.
Okay.
All right, defense, you want to examine the witness?
Please state your name for the record.
Joe David Munoz Jr.
Are you the same Joe David Munoz Jr. who testified in this trial, the State versus Guadalupe Contreras?
Yes, sir.
Were you in fact the very first, if you know, were you the very first witness in this trial?
I believe I was, yes.
I beg your pardon?
I believe I was, yes.
Okay. Are you also Joe Munoz 7347? At Joe Munoz 7347?
I don't remember.
You don't remember?
Mm-mm.
What's your YouTube, do you have a YouTube account?
Yes.
Okay, what's your login?
Actually, I remember the login that I do by face.
Do you have your phone on you?
Yes.
Take it out and log into YouTube.
It's not coming up.
What is your login address? Or what's your login name?
It's not coming up right now. I guess it's the signal. Or
You have a daughter named Emma Munoz?
yes, sir.
How old is Emma?
14?
Was she born in 2010?
Yes, sir.
Are you aware that this trial is being shown on the internet?
Yes, sir.
Have you watched any of it?
No, sir.
No?
Just, well, the glimpses from, I guess, from the news.
I'm sorry?
From the news, I have the KK12 News app.
Mm-hmm.
They post it up there and I just read the articles.
You have been reading the articles about it?
Yes.
What about watching stuff on YouTube?
It's on there.
It's on there? Yeah. Have you watched it?
Just what it pops up when I'm strolling.
Mm-hmm. Have you commented on it?
Yes, sir.
You have?
Yes.
Under the name Joe Munoz 7347?
I don't know, remember the
Once again,
numbers.
You don't know? How many times have you commented, if you know?
Once.
Once? Are you sure it was only once?
I think it was once, or same one twice, maybe.
Okay. Who has access to that YouTube account? You or Emma?
Both.
Both?
Yes, sir.
Can you explain why you made some comments and then all of a sudden the username on your account was changed from your comments were changed from your name to Emma's name?
We just changed it. Because Emma uses it as well.
Did you change it because you realized, oops, I'm not supposed to be doing this?
No, I just glanced through it and made the comments. I didn't, from what I remember, I was just told not to speak about it.
You don't remember that?
No, I was told not to speak about it.
Right. Yet you did, but yet you watched, but yet, who told you not to speak about it? And what did he tell you? He also told you what, not to read about it?
I just remember not speaking about it to anyone or
Right.
talking about it.
He told you don't talk about it, don't read about it. Yeah, but you read about it anyway. Right. How many articles did you read?
Just that one.
Just one.
Because I just assumed he meant like person to person. That's the impression I got.
Okay. So you're telling me you've never watched the live stream?
Not like a whole video, just that little piece where I made that comment. That's it.
Well, you made more than one comment. So if you watched
It was
more than
like
one
two, I
piece,
think. It was two comments. I
two
think,
comments.
on that one video.
Who all have you talked to about it?
No one, just myself.
Well, then how? So did you change the name or did Emma change the name?
I had Emma change it.
You had Emma change it.
Because I wasn't familiar with doing all that. And I don't remember my passwords in there.
Did you have Emma change it because you realized you were about to get in trouble, or what happened?
No, I just had to change it because I didn't know any of that. Like I said, I didn't think watching that piece and making that comment was relevant because I thought it was just, I couldn't speak to people as person to person. I didn't take it as the video part.
So it was okay to watch the videos and read the articles, just don't talk to people.
That's the impression I got when I couldn't speak to anyone about it.
So how many articles have you read? Honestly, and it's okay.
Well, I mean, just that one where I made the comment and then the articles from the news,
No, but
the one that comes up on there.
let's start with the articles.
Okay?
This thing's been going on for a long time, right? I mean, you testified like a week ago.
Yes, sir.
So there's been a lot of articles, right? And you read them all?
No.
Most of them?
No, probably I'd say about maybe 3, 4
You read 3 or 4 articles.
from that case at 12 at.
And what were those articles about? Let's start with the first one.
I don't remember exactly what they were saying. It was just pretty much a summary of what went on for the day.
You read, okay, so you read a summary of what happened that day. Okay. That was the first article. What was the second article about?
I don't remember.
Maybe a summary of the next day?
Yeah, it's pretty much, they were all pretty much the same summaries.
Did you feel like you had a pretty good idea of what you'd missed in, what had happened in court those 2 days?
No, because they didn't go into detail about anything. It was just talking about the process.
What
I mean, they
evidence-
don't show everything. They don't show what, like evidence or any of that stuff. It's just, I guess, the case at 12 making comments of where the court is at.
Okay.
They don't specify anything as far as what's going on.
Well, that's where the clips come in handy, right? They kind of fill in the gaps.
I just read the articles.
But you said you watched some clips.
Yeah, just that one where I made the comment.
So let's talk about the third article. What was the third article about?
I don't remember the specifics. Just to me, they were all just summaries. Yeah,
Okay. And what about the fourth article? Was it yet another summary?
they were all pretty much the same. What went on and what was going to happen next.
Okay, so, and they were, all 4 articles weren't all on the same day, were they? They were all on different days, right?
Yes, sir.
Okay. And what day did you testify, if you remember? Was it
I
Wednesday?
believe it's Thursday.
Thursday? Thursday, you're right, Thursday. So did you read an article that night when you got home?
I don't remember if I did it.
We can start till Thursday.
Which clip was it that you watched? When you say a clip,
Well, there was just like a live streaming, but I didn't hear it. It was just showing it.
you didn't hear it.
No.
How would you know to comment on something if you didn't hear what they were saying? You said, and I quote, "These people can't get their story straight." Why would you comment that somebody couldn't get their story straight if you weren't listening to what their story was? That doesn't make any sense, Joe.
Well, I mean,
It's
that's
okay.
how.
I mean, just tell the truth. You were listening.
Objection, may the witness be allowed to answer the question?
Yeah, you can answer the question. Remember that you are under oath.
Yes, sir.
Okay.
Joe, you said they can't even get their story straight.
Yes,
You
sir.
want me to believe you said that when you were watching something you couldn't hear?
Well, and mostly it's because I remember from the last trial. Recap after it was considered a mistrial.
So you made a comment about a video you couldn't even hear.
Yes. Because, I mean, I wasn't sitting there watching the whole thing. It was just little clips.
With no sound.
Hmm?
With no sound. Joe.
Yes, sir.
How long did you watch it with no sound?
Maybe a couple seconds, 3-4 seconds.
When was the last comment you made? Is that today?
Okay? No, sir.
So other than reading the 4 articles, you said you did some other things that did not include talking to people. What else did you do?
Just the articles.
Just the articles.
Yes, sir.
And when exactly was it that you told Emma to change it so it didn't have your name on it?
Yesterday.
Yesterday at what time?
Oh. It was in the afternoon, about 4 or 5, somewhere around there. I don't remember the exact time.
And when was it that you watched this video with no sound?
Well, it was a few days ago. It wasn't like
A few days ago?
probably, I'd say about 2-3 days ago, maybe. I don't remember the exact day in time.
And you said you only watched a couple of seconds.
Yes.
Who was there with you when you were watching it?
Just myself.
Just by yourself?
Yes, sir.
You were watching it on your phone or how?
Yes, on my phone.
Well, why were you doing that when the judge told you not to?
Like I said, my impression was individually speaking to people about it. I didn't really take it as the video part. I remember being told not to talk about it.
And you figured it was okay because you'd already pretty much read 4 days worth of summaries, so you knew what was going on
Yeah, in the
anyway?
case at 12 Act, yes, sir.
Yeah, you already knew what was, everything was going
Objection
on,
to
right?
counsel testifying at this point.
I'll let him ask the questions. I know, I think the record is clear that he's asking the questions, and so he is testifying, so we'll give him a little leeway.
Did you read the other comments
Which other comment?
on the YouTube? Your comments kind of respond to other comments. I'm assuming you read the other people's comments?
Well, yes, there was like 2 of them on there. I can't remember what they were saying, but
Really?
I don't remember exactly what they were saying.
Okay, let's go back to that first article. You said it was a summary of the day. Tell me about that article. What was it summarizing?
I can't remember the specifics, just like I said, it was just a summary of what they said happened that day and what was supposed to happen the following day.
Was it the same day you testified? Did it talk about you?
No,
It wasn't the day you testified? You weren't mentioned in that article?
not, No.
Okay, so it must have been the day after.
Probably. I don't remember the exact days.
But it was enough that you felt like you knew what happened that day.
Yeah.
Okay.
Just from the comments that I read.
From comments, I'm sorry, from the
The summary
articles.
that from the articles?
Well, you said comments. Do those articles have comments also?
No,
Do,
it just,
right?
it was just summaries from the KSAT 12 app. Like I said, it said what happened that day and what was supposed to happen the following day.
Okay. Well, when you say comments, do,
Well, I meant the article.
okay, okay. Do the articles have, like, do people comment on the articles?
No.
Okay. Now, when you go to, when I go to KSAT, the articles are also videos
Yes.
that talk about what happened. Is that what you're talking about?
Yes, it wants the clips of videos. On the video, it pretty much says the same thing the article does. It's
So
pretty
did you
much-
watch the videos and read the articles?
Yeah, the video is just of the, I guess, the anchors when they
Sure.
were talking about it. And they pretty much say the same thing the article says, the summary of what happened that day. And
So did you do both?
Yes.
So you watch the video, and in the video, the anchor kind of summarizes, hey, today in court,
Mhm.
blah, blah, blah.
Yeah.
And then there's an article that accompanies it and kind of may give a little more detail.
Yeah.
And so you did both. You watched the video, and then you read the article that went with the video.
Yes, sir.
And
Because
you did that 4 times.
Yes. Because on the post, it has, I don't know if you know, when you see the post, it shows the video.
Yes,
And
sir.
underneath it has a little article of what they
Okay.
think. So,
And to your recollection, you did not watch the one for the day you testified. So that means if you didn't do that, and that was, you testified on Thursday, so you watched Friday. You've watched every day since then. Monday, Tuesday, I mean, today's Wednesday, so every day, you've seen every day.
not every day. I mean, I do get on KSAT 12 in the articles there, but I don't read it. I haven't read it every day.
Okay, you've pretty much seen the whole, you pretty much know everything that happened.
Just what they say the process
And
is.
it, I mean,
They don't detail what happens in the court.
well, they summarize pretty much who the witnesses were, what they said, what the evidence, I mean, I agree with you, they don't show the pictures of the evidence, but they kind of tell you, hey, here's today, here's what happened.
Yeah, they just say like they present evidence, but they don't specify what it was or what was said or anything like that.
But it's enough so you kind of feel like you know what happened that day. All right.
You can kind of get an idea.
Now you realize you weren't supposed to do that.
Yes, like I said, I was under the impression because I was told that I couldn't speak about it or no one could speak to me about it. Like I guess I misunderstood about not being able to watch the KSAT 12 app.
Well, at least this way you learned a lot of stuff you didn't already know, right? I mean,
Objection, leading, counsel testifying.
Sustained.
well, the days you watched the articles and the video, the day first you watched the videos and then you read the articles, am I correct in all that stuff you learned, those were all days you didn't sit in court and watch. So all the stuff you learned, you would not have learned if you hadn't watched the videos and read the articles, right?
But to be clear, I didn't watch like every video. It was like one or two, if that. And most of it was just reading the article. Like I didn't sit there and watch KSAT 12's videos every day.
But there
Like
were
what
only
happened?
4. If you said you watched 4, we've only been in trial 4 days. So
I mean,
you
4
got-
articles.
But my point is, all the stuff you learned, you weren't in court when that was happening, so you learned all the stuff you missed, right? Okay. That's all I have, Judge.
State?
Yes, sir. So, Joe, after you read the articles, did you confer with any of the other witnesses or talk to any of the other witnesses about what you read?
No, ma'am.
After you watched the videos, did you speak with any of the other witnesses about what you saw on the videos?
No, ma'am.
I mean, Joe, the judge knows this, but you've been a part of this case since 2017, right?
Yes, ma'am.
And you've been involved in the investigation since 2017.
Yes, ma'am.
You spoke to the detectives back then.
Yes, ma'am.
So you already, as of 2017, have a lot of information about this case prior
Yes.
to watching any of the KSAT news articles.
Yes, I did.
So for example, prior to this trial, you talked to Jennifer Sierra about where Elizabeth may or may not have been, right?
Yes.
Okay. You talked to Janet Sierra about where Elizabeth may or may not have been.
Yes, I did.
You talked to Officer Rodriguez about your vehicle that they took and put it in the 9th Street.
Yes, I did.
You talked to Detective Espinosa, who was the lead investigator in this case, right?
Yes, I did.
Okay, so you talked to a lot of people that were involved in this case and testified in this case prior to trial, right?
Yes, ma'am.
But just to confirm, once the trial was started and you read those articles, you did not talk to any of those witnesses about what you read?
No, I did not.
So what was your understanding of the rule that you were under as a witness in this case?
Just that I couldn't verbally speak to people individually as a one-on-one. I couldn't talk to them about the case, or they couldn't talk to me about the case. And that's how I understood it. I misunderstood.
And have you followed the rule as you understood it?
Yes.
Now, Joe, if for some reason either the state or the defense were to want to call you to finish up something, some other piece of testimony or evidence that we haven't covered with you previously, would the articles that you read, would it affect any testimony that you would give after today?
No, it
Calls for
wouldn't.
speculation. He can't anticipate what the questions would be, so he didn't possibly know the answer to that.
My question is what he read, would that affect his
Well,
testimony?
he doesn't know what the questions would be, so that calls for speculation.
You can rephrase your question.
So, Joe, if you were to testify after you've read those articles, would you still testify truthfully?
Yes, ma'am.
Okay. Would having read those articles change your truth?
No.
Nothing further.
Defense, anything else?
No.
Let me ask you a couple questions.
Yes, ma'am.
All right, so you got the instructions that I gave you from the last trial,
Yes, sir.
and you also got instructions I gave you after this trial.
Yes.
Okay. Did the state, anybody from the DA's office talk to you at all about what those instructions meant?
It's just not to speak to anyone about it. I couldn't talk to anyone.
What did the state explain to you? What were the rules as it related to your communications with others while this trial was pending?
Just that I couldn't speak to, or no one could speak to me about the case.
And you're telling us that that meant to you that speaking only means verbally, doesn't mean anything about writing.
Yes.
That's what you're telling us.
Yes, I was speaking to someone individually, like I couldn't talk to someone. Like if I'm talking to you, to me it's different talking to you and then making a comment.
What does it mean to you when someone tells you don't talk to anybody about any of the evidence or testimony that they would give if they're a witness in this case? What does that mean to you?
To literally not to speak to anyone about it.
What would the purpose of that be? Why would you be instructed not to talk to anybody?
For the case.
Is it because maybe you're not supposed to get information from them about what they testify about?
Yes.
Isn't that the same thing as watching a YouTube video? Isn't that the same thing as watching TV reports?
And on the videos, they don't really go into detail about what happened in the court.
This is a YouTube video we're talking about, right?
Yes.
And the YouTube video that you've testified about shows the entirety of the trial,
Yeah.
right?
And I didn't watch like the whole video. It was
You watched enough to comment.
just
Okay, what were your comments?
about getting their, not having their story straight.
What does that mean? What did you mean when you said that?
It just seems like they didn't,
Who is, let me interrupt you. Who is they?
I can't remember who was talking at the time.
If it inspired you enough to write something on YouTube, then you know who was talking at the time. Who was talking at the time, and what did you mean when you said they can't get their story straight?
Just, I can't remember.
Oh, you can remember. It was only a couple days ago. How many times did you watch a YouTube recording?
Just like twice.
Okay.
A few seconds here and there.
Okay, so if you saw it twice, then you know who was testifying, right?
I saw,
That's a yes or no question.
oh yes,
Okay.
sorry.
So who was testifying when you made that comment?
One of the detectives, I can't remember his name, like the bald one.
Okay, so what you're saying is you're saying that the police can't get their stories
What
straight?
are the questions they were asking him?
Who's they?
The defense.
Okay, so you're saying the defense can't get their story straight.
Yeah, because to me, the questions they were asking were, like they were going back and forth. And, like, ask one question and jump to another, like normal, but to me, I mean, I'm not a professional, it just seemed like they were just trying to get answers, different answers,
Okay,
repeating their questions and
okay.
hoping that they would come up with a different answer for, I don't know.
Okay.
Like, I don't know, like,
That's your first comment. What was the second comment you testified about? What was that?
I can't even remember what the second comment I wrote, honestly.
Okay, so you know before you came into this courtroom that that was not a correct thing for you to do, right?
Yeah.
Okay, so what was your second comment? Because I'm certain that when you said, uh-oh, right, you told yourself, uh-oh, I didn't do something right, right? You told yourself that.
Well, because I wasn't sure.
That's
like,
a yes or no
Oh,
question.
yes.
Okay.
Sorry.
And then when you told yourself that, then you analyzed and you look back and you said, what did I say? What did I write? Correct?
Yeah, we,
So you know what you wrote.
right
Correct?
now, right now.
Hold on. That's a yes or no question. You know what you wrote, correct?
I just don't remember. Sorry.
You don't remember.
I know I wrote something, I just don't remember what I wrote right now.
So you know when I instructed you, and the state instructed you as well, so what the rule meant, right? Because the state talked to you about it too. Yeah, is that a yes or no?
Yes.
So you have two separate entities. You have the court and you have the prosecutors give you the same instructions about not getting information about this trial because you're a witness.
Yes, sir.
And you understood that, didn't you?
Yes, sir.
Couldn't help yourself, could you?
It was on the app, and
You couldn't help yourself, right?
this is a major deal.
What was that?
This is a major deal for me, like,
Yeah,
the
this
mother of my child.
sure, this trial is a major deal too to the taxpayers of this community, right? But you put yourself over the taxpayers, over the community, over the integrity of this case. Is that what you did?
Yes, sir.
All right. Any other questions from either side?
No, Your Honor.
No.
All right. I'm gonna listen to the instructions I gave you, okay?
Yes, sir.
Don't be, if you're confused, let me know. I'm gonna instruct you to exit the courtroom. Don't leave, wait until one of the parties tells you that you can leave.
Okay.
All right, you're excused. Anything from either side?
Yes, Judge, 100%. I don't know how on earth this court can even consider going forward with this trial when this witness under oath told me I didn't listen to anything, I only watched the video with no sound. Then he told you he was listening to the questions between me and a detective, and based on what he heard, he thought I didn't understand and I was trying to trick up and I couldn't get my story straight. So he's either lying to me or lying to the court. And if he'll be that brazen in his attempt to get through this little hearing, he cannot be trusted when he tells the state, oh, don't worry, I can tell the truth if I need to. I mean, he said, when I watched a 3-second snippet of YouTube, I had the sound off. Then you asked him, what did that mean? He said, well, I was watching YouTube and I was listening to the questions between the defense and the bald detective, and those questions made it sound like the defense couldn't get his story straight, which clearly means he had the sound on. So, Judge, if he's going to sit here in this hearing and mislead the court, then how on earth can the court be comforted that if this trial was to proceed and he was to be recalled, his testimony could be trusted? Because it can't even be it can't be trusted in this instance. I mean, nothing could be more obvious than that exact question and answer you and I just had with him. He told me one thing specifically and told you one thing that was completely different. Completely different. I have no faith at all in the fact that he would sit here in a trial in front of a jury with my client's life on the line and tell the truth if he can't even tell either you or me the truth about something as simple as I watched a video with the sound off or the sound on. Judge, I have no choice. I move for a mistrial. He is the last witness potentially to have seen Ms. Contreras alive. He's subject to recall. He was instructed by this court, and even in a hearing as simple as this, he perjured himself. He was very clear to me the sound was off. He was very clear to you. I listened to their questions on YouTube, and it sounded like they couldn't get their story straight. The state's going to get up and say he was confused and he didn't understand. It wasn't confusing. He had the sound off for me. He had the sound on for you. He cannot be trusted. And if he can't be trusted to tell the truth in that, how can he be trusted to tell the truth in something as serious as this if he was recalled to testify? For those reasons, he's violated the court's order. Whether he understood it or not, I don't know. Apparently the state didn't do anything in addition to what you told him clearly what to do and not do. He didn't care. He didn't do it. And when he had the chance to clear it up and to say, hey, Judge, I'm sorry, I should have done better, he still chose to lie to the court or to lie to me, one or the other. And we can't have that in this trial. We just can't. I know the state's going to say the case law says you can let him testify. He can be rehabilitated. Judge, that would be the case if he had told the truth today. I understand what the case law says. I know the court can say, hey, we can get past this. And we could have. If he had proven today he can be trusted. But he proved today he 100% cannot be trusted. It's at the discretion of the court, but nothing can be more brazen than what we just saw. And I have no choice but to move for mistrial.
And Charles is right. I'm going to say, and Your Honor heard, Mr. Munoz clearly is not the most sophisticated person. I'm trying to be kind, you know. He's not even a high school graduate. He's here doing the best that he can. These legal issues are complicated. Even us as attorneys get things mixed up, right? So he told the court he didn't fully understand. He misunderstood. He was not trying to violate the rule. But more importantly was that he didn't talk to any of the other witnesses about what he read, so he hasn't infected any of the witnesses' testimony. And in addition, his testimony was first. So his testimony was not affected by anything and could not have been affected by anything that he read. And I think most importantly is that Mr. Munoz is seeped with this trial. He's seeped with this investigation. So to say that him reading a summary on KSAT is somehow going to so affect the defense's ability to call him back. Well, we haven't heard anything that the defense wants to get into that he's prevented from getting into by Joe watching KSAT. What's getting in his way? The fact that he maybe watched a few articles? How does that affect anything of substance for this trial and for this defense? I wish maybe I could have been more clear with the rule. I know you, Judge, you think you are too. We all think that we're clear, but we've all been in situations multiple times in trials where we think we're clear to either the members of the jury or to our witnesses, and then something comes up and something happens, and they don't understand. I don't think that he was intentionally trying to violate the court. I do not even think today he was intentionally trying to be dishonest with Mr. Bunk or with yourself, Your Honor. I don't think he understands. So to say mistrial after all this time is just not warranted in this case. If for some reason Mr. Bunk does want to recall Mr. Munoz in his case, then this could be fodder for cross-examination. Anything that Mr. Munoz says different than his testimony from the first trial, from his statement to Detective Espinosa, to this trial, to anything that he just said in this hearing, that is all perfect fodder for cross-examination. He can put his credibility at issue with his jury, and that's the way to do it. No mistrial is warranted, Your Honor. If there is some other remedy, whether it's contempt of court or you want me to admonish him even further, we're happy to oblige. But a mistrial is just not the remedy that is required by the law, and we ask that the defense request for mistrial be denied.
All right, at this time, I'll deny the motion for mistrial. I think you got the point. So,
Thank you.
all right, anything else before we bring the jury back in?
Nothing from the state judge.
Defense?
Judge, I ask that you hold him in contempt of court. I mean, I don't know, and I can't, he's put the court in a position to where he's made you a fact witness to his credibility. I mean, just, nothing further at this time. I ask you to hold him in contempt. That's all I got.
All right, I'll consider it. All right, let's go and bring the jury.
Tell Greg, just briefly. Yeah, just 1 second. Charles wants to talk.
Oh, no, they're ready. You
Just 1 second, Your Honor. Charles just wanted to talk to Robert real quick about that 702 issue that we talked about yesterday, just to make sure that the science hasn't changed. I think that's it. Right?
Judge, yesterday we spoke briefly regarding 702. I have had a chance with Mr. Sailors, as we discussed yesterday, regarding the 702 hearing and the DNA evidence. I've had a chance to speak with Mr. Sailors in the hall, as I did with Ms. Vachon and Mr. Foster yesterday. I'm satisfied that the science on his testimony, specifically Mr. Sailors and the DNA, is the same science in place as was in place at the prior trial and the hearing that we held regarding 702 for his testimony. I think the volume and the page were cited yesterday. I'm satisfied that the court would hear the same evidence. I'm satisfied that he would testify that the science has not changed, the validity, the technology, the science is still the same as it was. I anticipate the court's rulings would be the same. I don't see a need for an additional hearing, but I have had a chance to ask him those questions. He wasn't present yesterday for me to ask him those questions, so I'd asked yesterday for an opportunity to speak to him before the court ruled. I have had that chance. I am comforted that he's satisfied my curiosity that the science has not changed, so I just asked the court to consider the same evidence it heard at the last 702 hearing regarding Mr. Saylor's testimony on the DNA evidence.
And so you're objecting?
I'm not objecting. I'm just asking the court to hold the 702 hearing, or considering the same evidence it heard at the last trial.
Okay.
Okay.
And so yes, I will consider the same 702 evidence. You guys have the information?
Yes, sir.
We read it into the record yesterday.
Oh, okay.
You didn't rule because I hadn't had a chance to check with Mr. Saylors just to verify that the science had not changed.
Okay.
And now I'm telling the court that I'm comfortable that the science has not changed and I do not need any additional testimony.
Got it. All right. And so the court will reconsider the same testimony and evidence from the prior hearing.
Thank you, Judge.
You're welcome.
Ready, guys? All right, for the jury. Are you good? You're ready to show Maybe seated.
Welcome back, members of the jury. State, call your next witness.
Thank you, Your Honor. The state calls Robert Saylors.
So you know I wouldn't have to do that. So I wouldn't fit through. All right, I'm going to swear you in. Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. You can introduce yourself to the jury and spell your name for the court reporter, please.
Good afternoon. My name is Robert Saylors. Last name is spelled S-A-I-L-O-R-S.
State.
Thank you, Your Honor. Good afternoon.
Good afternoon.
And Robert, we've met before, correct?
Yes, ma'am.
That's okay if I call you Robert?
Yes, ma'am. Of course.
And so, just tell the jury what kind of work you do.
I'm employed at the Bexar County Forensic Science Center as one of the supervisors of the forensic biology unit.
Okay. And what's your educational background?
I have a Bachelor's of Science degree in biology from Texas Lutheran University and a Master's of Science degree from the University of Texas at San Antonio.
And how long have you been with the Bexar County Crime Lab?
I'm working on my 28th year now.
Do you have any additional certifications that you have with regard to your work with the crime lab that you do?
I am licensed by the Texas Forensic Science Commission in Texas as a forensic practitioner, and I'm also board certified by the American Board of Criminalistics.
In order to maintain that license and that board certification, are you required to take additional continuing education classes and that sort of thing?
Yes, ma'am. Continuing education, proficiency testing. Yes, ma'am.
Great. And so, we're here today to talk about DNA, right?
Yes, ma'am.
Okay. So, I know probably since 23andMe and all of the CSI shows, most of us have a general idea of what DNA is or isn't. But just to make sure we're all on the same page, from your perspective as a forensic scientist, could you kind of give all of us the sort of 8th grade Cliff Notes version of what is DNA?
Of course. Basically, in a nutshell, DNA is a molecule inside your body that contains all the information necessary to make you who you are. That you have 2 arms, 2 legs, hair color, eye color. And so it has the ability to differentiate between individuals, but we also share a lot of our DNA with each other because, again, much of what makes us who we are is very similar to the person next to us. It is inherited from your mother and your father. You get half of your DNA from your mom and half of your DNA from your dad. So their DNA kind of shuffles together like a deck of cards, and then you're kind of dealt the hand of DNA. And so in that sense, your DNA to you would be unique to you in some areas, with the exception of identical twins. And that's what allows us to use it in a forensic setting to make determinations of who may or may not be a contributor of biological material.
Right. So, and how long have you been doing that work?
Maybe 26 years, 27 years.
And so then back in 2017, were you working with the crime lab?
I was, yes.
And were you doing this sort of work, DNA analysis and comparison?
Yes, ma'am, I was.
And did you happen to work on a case with people by the name of Elizabeth Contreras and Guadalupe Contreras?
Yes, ma'am, I did.
And did you write a report with regard to your work, or reports with regard to your work in that case?
I did, yes, ma'am.
And when you made those reports, were they the sorts of reports that you make in the normal course of your business as a forensic scientist?
Yes, ma'am, they are.
And then do you make those reports at or near the time of your work?
Yes, ma'am.
Yeah, Coach Arm.
Yes.
What's the last number of the state? Next one's going to Thank you. So Robert, I'm going to show you what has been marked as State's Exhibits 220 and 225. Will you please examine them? 235. Let me make sure I read that right. 235. I did write it correct. I said it wrong, but read it right.
Okay. Yes, ma'am, I recognize these.
Okay, and so do States 220 and 235, do they appear to be copies of the reports that you generated with regard to your work in the case of Elizabeth Contreras and Guadalupe Contreras?
Yes, ma'am.
And so again, these are the ones that you made at or near the time that you did your DNA analysis?
Yes, ma'am.
Okay. And are you the custodian of these records?
I am.
Okay. State moves to admit States 20 and 235, 220 and 235.
No objection to 220 or 235.
All right, they're admitted.
Thank you, Your Honor.
You're welcome.
And so, Robert, before we actually kind of get into the details and substance of your reports, there's some language in here that I was hoping you could just explain for the jury. So, for example, can you tell them what a buccal standard is?
Yes, ma'am. A buccal standard is a swab that is collected from inside of an individual's mouth, and it serves, the purpose of it is to serve as a reference sample from that individual, meaning that the DNA profile that we get from that swab serves as the known profile of that individual and serves as a point of reference.
Okay, and then What about insufficient quantity or quality of human DNA?
When we reached that conclusion, that just means that there was not enough DNA present on the item for us to make a determination or to come to a conclusion. So the conclusion is that there's just not enough DNA present.
So then kind of let's start to talk about the jury heard from Garen yesterday. He tested some items that were presumptively positive for blood. Did you only test for DNA those items that were presumptively positive for blood?
I believe most of the items are the ones I tested were presumptively positive for blood, but I haven't cross-referenced each item to see whether it was one that was presumptively positive.
Okay, so maybe.
So it's most likely the items that were presumptive positive for blood were retained by Mr. Foster, and then I tested them. But whether every item that I'm going to testify to had blood on it, I can't say.
Makes sense. So how do you start your process once Garen or serology has finished their work? What is your first step?
Well, once I take possession of the evidence, it's kind of a multi-step process. Do you just want me to walk through the process of performing DNA analysis, or?
Yes, start slowly.
When we begin, we're going to start off with the items of evidence, the evidence items, which are the non-reference samples or the non-buccal samples or not the known blood standard of an individual. But we treat the items the same. They go through the same process, but we process them at separate times to avoid any type of cross-contamination. We're going to start off with doing an extraction, which basically is we're going to use some detergents, kind of similar to what's used in laundry, and some other biological molecules to kind of open up the cells and get the cells to spill out their DNA into solution. And then we're going to purify that sample by pulling the DNA out of the sample, leaving behind all the stuff that we're not interested in, all the other fats and proteins and stuff that are in the cells. We're then going to move that sample forward to what's called a quantitation step, where we're going to measure how much of the DNA that's in the sample is human and what's the concentration of the human DNA in there, because we need to know that for the next step. The next step is called amplification, where we take a targeted amount of DNA based on the quantitation, and we're going to amplify that DNA or make copies of the region of interest that we're interested in. And we're going to make millions of copies of these specific regions of DNA. And by doing that, we're also incorporating it's a small fluorescent molecule that'll get tagged to that DNA. So then we can then take that amplified DNA with the fluorescent markers on them and run them through what's called a genetic analyzer. And the resulting pattern that we get in that genetic analyzer is what your DNA profile is. So it looks like a series of peaks and valleys. And then once we do that with all the unknown items, we do that with the reference items, and we compare the patterns together and make a determination on whether or not a known profile from an individual is either not excluded or excluded as being a contributor of the DNA on the crime scene evidence.
Okay, so then specifically the case that we're here for today, did you then in turn analyze some patterns of some known standards with some pieces of evidence that were submitted to your office and the patterns that you pulled from those, I guess, can I say unknown item? Does that sound fair?
Yes, ma'am. We call them unknown items, or you can refer to them as crime scene evidence. So basically it's just an item of evidence that we don't know ahead of time what the profile is going to be.
Right. And so then are you trying to see if any of the unknown items, if their pattern matches to your known pattern standards?
Yes, ma'am.
So then let's start. How about we start with State's Exhibit 20? I'm going to put it up on the screen, but you let me know if you can't see it in front of you or if you walk along with your own. Okay, we'll just kind of start at the top, just in general. What is the jury looking up at this top heading? What's the point of that information?
This is the header on the report, which contains the title of what type of scientific analysis or what discipline it came out of. So at the top there, you'll see Bexar County Criminal Investigation Laboratory. And then underneath that, you'll see a forensic DNA report. That means it came out of the forensic biology unit, and has the date that the report was issued, the name of the detective and agency that requested the work and who it's addressed to. And then it also has what's called a CIL case number, which is a case number that we assign to it, which is unique to the submitting agency. And then we have what's called a case record. It would be the which number of record was requested to be done by the laboratory. And then we have an SAPD case number and names of any complainants and or suspects in the case.
Okay, so since your case record is number 2, would that mean that Garen's was number 1 for this particular work?
Yes, ma'am.
And then the CIL number, that is going to be similar. You and Garen are going to have that same number attached to the work that you do.
Yes, ma'am. Any work, once that number is assigned, so any additional evidence that would have come into the laboratory under that exact SAPD case number would be cross-referenced to that CIL number, so they're kind of paired together.
So then moving up a little bit to the next section of your report, the evidence received. So generally, let's talk about your items 1 through 6 first, in general terms, what it was.
These are the items of evidence that were previously tested by Mr. Foster and retained for DNA analysis. And so it's an inventory of the items of evidence that I pulled out of the biological sample storage, which, is basically where we store evidence that's waiting analysis. And then it lists a date there that I took possession of the evidence.
And then the designation after yours, so I'm guessing this 1-1.1, that's your designation, correct?
Yes, ma'am. So Mr. Foster would have designated that item as 1-1 when he processed it. And then when he took a sample of it to retain for DNA testing, he gave that retained sample or portion of it a .1 designation so that the parent item 1-1 could be returned to SAPD.
Okay. And so then the description afterwards is more of the description from San Antonio Police Department.
Yes, based on the descriptions on the packaging.
Okay. And so may I approach John?
Yes.
So for example, Robert, will you look at State's Exhibit 117? And is this kind of what you're talking about?
Yes, ma'am. So this container of evidence was given a designation of Exhibit 1 by Mr. Foster, and all the items into it that are inside of it would have been subsequently called 1-1, 1-2, 1-3, and then the samples that he took from these for DNA testing get the .1 or .2 designation.
Okay. And so then can you just mind opening up the bag and just see, are there multiple envelopes in there that would just coincide with your 1, 2, 3, 4.
1, 2, 1, 1, 1, 2, 1, 3, 1, 5, 1, 6, and 1-4. So 1-1 through 1-6.
Okay. And so then is it safe to say that the next groupings in your report would be similar to what we just showed the jury in States 117?
Yes, ma'am. They would just come and they would have been inside a different container. That would have been item 3 or 4, 5, or 6.
And then the last 2 items, you already kind of explained to the jury what the buckle standards are. Is that what we're looking at in your item 8?
Yes, those were submitted as the known reference samples of Guadalupe Contreras and Joe Munoz.
And then it looks like there was a second submission down here. You want me to flip the page onto page 2? Can you explain for the jury what the second submission was?
Yes, ma'am. There were 2 additional submissions that were brought into the laboratory, and these were items from the Bexar County Medical Examiner's Office, which were submitted to serve as the known reference sample of Elizabeth Contreras, and a portion of muscle tissue and a portion of kidney tissue was submitted as a reference sample from her.
Okay, and so then for items 8 and 9, those known standards, were you able to create a genetic profile for Elizabeth Contreras, Joe Munoz, and Guadalupe Contreras?
On, let me see. The muscle tissue, I was unable to generate a genetic profile from. That's the item 9-1 there, just due to the condition of the tissue. But from the known reference samples of Guadalupe Contreras, Joe Munoz, and the kidney tissue of Elizabeth Contreras, I was able to generate a genetic profile.
And so is that why we have the item 10, the second submission for Elizabeth Contreras?
Yes, ma'am, because the first one didn't work.
Okay, and were you able to create or generate a DNA profile for Elizabeth Contreras based on submission 10?
Yes, submission 4, yes, ma'am.
Oh, sorry.
It's okay.
Submission for item 10, is that
It's okay, yes, ma'am, absolutely, yes.
Thanks for keeping me straight. All right, and so where did you get the submission number 4 from?
We work in the same building with the Bexar County Medical Examiner's Office, and so it makes it relatively easy. Like whenever we're working for an agency and they need a reference sample from a deceased individual, we request that the Bexar County Medical Examiner's Office take a sample that they collected during autopsy and submit it into the crime laboratory.
And so then now moving on to, can I call them unknown samples? Is that okay?
Sure.
Moving on to the unknown samples, were you able to create DNA profiles for every single item of unknown?
From every single item? No, ma'am.
Okay. So then what's easier for you, for us to start with the ones you were or weren't? How do you want to do it?
Well, I guess we could start with the ones that I was not able to.
Okay, let's do that. Talk about which items you were unable to create a genetic profile for.
If you would turn to page 4 of that report. Just above that section in bold that says remarks, you'll see a paragraph there where I document the items that contained an insufficient quantity or quality of human DNA to develop a DNA profile suitable for comparisons. And that was swab tips, E5 from the driver's side interior door panel, which was our item 1-5.1. Swab tips from the E7B straw, item 6-5.1. Swab tips from E7B cup, item 6-6.1. Swab tips E7C plastic lid, item 6-7.1. And then, as previously mentioned, the muscle tissue of Elizabeth Contreras.
Okay, and I'm going to show the jury a series of photographs. Now these have already been admitted into evidence, and you may not be familiar with these photographs, but so State's Exhibit 9, the jury has already heard testimony that this is an E5 taken. And so then you have an E5 as the driver's side interior as one of the areas that as one of the items that you were unable to find a profile.
If that is the E5 on my report, then that is correct.
And so same question in State's Exhibit 174, if from the prior testimony that the jury's heard, if this is the same E7 that SAPD collected in this case, then that is also an item where you were unable to make a DNA profile.
Yes, I believe we had an item E7B. I'm sorry, E7B, which was swabs from a straw and swabs from a cup.
Okay, well then let's flip back to page 2. And let's begin to talk about the unknown samples that you were able to create a genetic profile on. Are they listed on page 2 of your report?
That is where they would begin, yes, ma'am.
Okay. So then let's go down. Can we go down to this paragraph based upon these analysis? Okay. So can you read this paragraph and then explain for the jury what it means?
Okay. The paragraph reads as such that based upon these analyses, Elizabeth Contreras is not excluded as being the major contributor of human DNA identified on swab tips E1, front driver's door interior panel, item 1-1.1. Do you want me to go into the...
Before you do that, can you explain to the jury what you mean by major contributor? Is that significant in your work?
Well, it can be. You know, we quite often have samples that contain mixtures of DNA. And when we talk about major contributors and minor contributors, we're talking about, you know, who's the predominant donor, and, you know, the minor would be the less dominant donor. But sometimes we have a complete profile, or, you know, a profile with just a very small amount of a contributor of DNA that maybe we can do something and make a comparison with the major donor, who's the primary donor of the DNA, but maybe we can't do anything with the minor component. There's just not enough of it. And what I'm talking about here is that, you know, there was indications of multiple donors on this item, and that Elizabeth Contreras could not be excluded as being the donor or the major contributor on this item of evidence.
Okay. And so then, kind of the same thing that we did, so if the jury heard prior testimony looking at State's Exhibit 105, that this is the E1 swab that the officers took that comports with E1 on the front door.
Okay, yes, ma'am.
All right, so then go ahead and move on. Well, you know, before we do that, explain to the jury why you put it in those terms as not excluded.
Well, you know, as much as we'd like to be able to, we can't say that an individual is the donor of the DNA, because everybody in the world's DNA has not been tested. So what we do is we look at a lot of different genetic markers, and we look at like 23 or 24 of them now, and we're trying to increase our power of exclusion, increase our ability to exclude somebody from being a donor of the DNA. And if we are unable to exclude them, meaning that they're not the donor, then we say that they are not excluded. And that's just kind of another word for basically saying that, you know, the DNA profiles between the two items match. We're not saying it's the same person. We're just saying that the DNA profiles are consistent with each other.
Okay, so for example, when you looked at the pattern of the E1, your item 1-.1, and then the known pattern of Elizabeth Contreras, you couldn't exclude that they were not potentially from the same source.
That is correct.
So then let us go down. Do we need to explain sort of the second half of that paragraph to the jury before we move on?
The part dealing with the statistics?
Yes, yeah.
It's important. Whenever we make what's called a positive association, that basically an individual cannot be excluded, we need to perform some type of statistical match weight to that item. And on this particular item, and based upon the amount of DNA I had on the item and the profile that I developed, I was able to take that DNA profile and calculate what we call a random match probability. This number would tell you statistically what are the odds of being able to go out and randomly choose people from the population that would have the same profile as was developed from the driver door interior panel. And on this particular profile that was developed from this item, today we report out the smallest number. So on this report you'll see 3 different numbers there, but now we report out the smallest, what we call most conservative number. And so that would be the Hispanic statistic there. And so the DNA profile from that item from which Elizabeth Contreras was not excluded would be expected to occur in about 1 in every 1.278 quintillion individuals. So what does that mean? Statistically speaking, that means that you would need to get 1.278 quintillion randomly selected individuals together before you would be expected to see that profile one time. And that's called a random match probability.
Do you happen to know the entire population of the Earth right now?
Of the Earth right now?
Is it a quintillion?
No, we're still in the billions.
Okay. So then, next paragraph. So kind of the same thing. Just read that first sentence right there.
Based upon these analyses, Elizabeth Contreras is not excluded as a source of the human DNA identified on the swab tips E2 steering wheel, our item 1-2.1.
So I'm just going to kind of go through that same pattern. If the jury's heard evidence previously about a steering wheel that I'm showing in State's Exhibit 92, and then an E2 swab that was taken from that steering wheel, that would comport with your E2 steering wheel swab that you tested, that you could not exclude Elizabeth Contreras as the contributor to that item.
Yes, if that's E2, yes, ma'am.
Is there anything else about that paragraph before I move on to the next page?
No, there's just the next page would have the random match probability calculation.
And it looks like the random match on this one is larger than even the one that we had previously.
Yes, the numbers can go up and down depending on how complete the profile is and how, kind of really how much of the profile we can develop. So the more DNA that's present, the more complete the profile is, and so therefore typically that results in a higher statistical number. And so for the swab from the steering wheel, from which Elizabeth Contreras was not excluded, that profile within the Hispanic population would be expected to occur in about 1 in every 3.8835 sextillion individuals.
Okay. And so is that the significance of your different paragraphs and the way you're sort of organizing this? Is it by that statistical measure?
Yes, ma'am. I'm trying to group them based upon their completeness. So there'll be some paragraphs that every item has a complete profile, and so they'll have like a shared match weight. And other ones, there may be some loci that are missing due to degradation or the quantity of DNA that was present.
So then moving on, go ahead and read that first sentence, and then we'll kind of talk about the pictures and items of evidence.
Okay. This one's going to have multiple items
Okay.
in it. And based upon the results of my testing, Elizabeth Contreras is not excluded as a source of the human DNA identified on the swab tips E3, front driver's side visor, item 1-3.1, E6, piece of paper, item 1-6.1, swab tips E1, driver's side rear cargo, item 3-1.1, cutting from E7, the brown towel, item 3-5.1, cutting from E1A, black t-shirt, item 4-1.1, swab tips E04, roadway, item 6-1.1, and as the major contributor of the human DNA identified on the swabbing from the lid, item 1-4.1, swab tips E2, center rear cargo, item 3-2.1, and cutting from E1E, gray shorts, item 5-1.1. I apologize for that long sentence.
All right, so then I'm just going to kind of show the jury what they've previously seen in admitted States Exhibit 1-7, SAPD's E3, the visor. States Exhibit 110, the letter. I guess you kind of called it paper, a piece of paper.
Yes.
And then States Exhibit 230, is the rear cargo. And then States Exhibit 111, the brown towel. And then when we get down to the other items, you've already seen these, so I'm not going to make you take them out, but does it look like the comparisons of the labels comport with what your designation is? So States Exhibit 207 and 206.
See Exhibit 5. Yes, ma'am. Some of the subsequent items would have originated out of these two packages.
So for example, you didn't get the whole bag, but you got a cutting from these items.
Correct. I've never seen the bags or the actual evidence that's inside there.
And then again, the cuttings from the shirt and the shorts, who was not excluded as the source of DNA on those items?
It was Elizabeth Contreras.
And was that even a larger statistical number than the previous paragraph?
Slightly. It was a bit more of a complete profile, and the lowest calculated random match probability for those items grouped together had a random match probability of 1 in every 490 septillion individuals.
All right, and so then let's move on to that next paragraph. Would you just read that first sentence, please?
Yes, ma'am. Elizabeth Contreras is not excluded as a source of the human DNA identified on the swab tips E06B tire, item 6-4.1.
So I'm showing the jury States Exhibit 167, which is SAPD's E6, the tire. All right, so do you want to talk any more about that paragraph, or do you want to move on to the next section?
Unless you wanted me to go over the random match probability for that item.
I think the jury got it.
Okay.
Okay. All right, so then let us move on to the next one. Is it this paragraph, is this where we are?
Yes, ma'am. And that particular paragraph is making a statement regarding the items of evidence in which I said Elizabeth Contreras was not excluded as the major contributor.
Okay.
And I'm simply stating that additional human DNA, which could not be attributed to Elizabeth Contreras, was identified on the swab tips E1 front driver's door interior panel, item 1-1.1, E4 swabbing from lid, item 1-4.1, swab tips E2 center rear cargo, item 3-2.1, and cutting from E1E gray shorts, item 5-1.1. And I go on to say, however, there was an insufficient quantity and quality of this additional genetic material to develop a DNA profile suitable for forensic DNA comparison.
Okay, so there was a profile there, but you weren't able to, I guess you didn't have enough material to kind of create a full pattern profile?
Not enough for me to make a conclusion.
And that was States Exhibit 108. This one's really hard to see. States Exhibit 231. That's right. Yeah, that's right. This should be a 2 right there. And then the shorts, which we're not going to pull out, but the ones that you already referred to in the back.
Yes, ma'am.
Okay, and so then let's go down to, I guess, this last complete paragraph on this page. What are we looking at here?
All right, we're switching individuals, known profiles here. Not switching their profiles, but switching to talking about different individuals here. This paragraph is a combined paragraph dealing with the known genetic profiles of Guadalupe Contreras and Joe Munoz, where I go on and I determine that they were excluded as a source of the human DNA identified on the swab tips E2 steering wheel 1-2.1, swab tips E3 front driver's side visor item 1-3.1, E6 piece of paper item 1-6.1, swab tips E1 driver's side rear cargo item 3-1.1, cutting from E7 brown towel item 3-5.1, cutting from E1A black t-shirt item 4-1.1, swab tips E04 roadway item 6-1.1, swab tips E06B tire item 6-4.1, and they were also excluded as being the major contributor of the human DNA identified on the swab tips E1 front driver's door interior panel item 1-1.1, E4 swabbing from lid item 1-4.1, swab tips E2 center rear cargo item 3-2.1, and cutting from E1E gray shorts item 5-1.1.
Okay, and so those are all of the similar items that you did not exclude Elizabeth Contreras from, but you did exclude Guadalupe Contreras and Joe Munoz as a source to contribute to those items.
Correct.
And then flipping the page, well, I guess read that first sentence and then I'll flip.
Towards the bottom there?
Yeah, that very last, that isn't a complete sentence.
Okay. This next statement states that based upon these analyses, Joe Munoz is not excluded as a source of the human DNA identified on E4 swabbing from straw, item 1-4.2.
And so then the jury heard testimony that this was the E4 in States Exhibit 108, and that would comport with that. Okay, and then do you want to talk about that statistical analysis? Is it different than kind of what you've talked about already?
I mean, it's just a different number. I mean, I can, if you want me to.
No, it's okay.
Okay.
And then I think you already talked about the insufficient quantity, so the last thing that we need to talk about, I guess, is this little paragraph right here.
Yes, so pertaining to that same item, excuse me, that I just testified about, the swabbing from the straw from E4, concluded that Guadalupe Contreras and Elizabeth Contreras were excluded as a source of the human DNA identified on that item.
Okay, so did we cover everything, or did I miss anything?
That is it from that report.
So then, what was the second work that you did, the report that you generated in States Exhibit 235?
The second report was evidence that came in under a different SAPD case number, and so therefore it has a different CIL crime lab case number on it, but it was identified as involving the same individuals.
Okay, and so then what work did you do with regard to this report under States Exhibit 235?
This was evidence that was collected during autopsy, and what was submitted was head hair standards from Elizabeth Contreras and clippings of her right hand fingernails.
And were you able to form a conclusion around the head hair standards?
On the head hair standards, those were submitted for hair comparisons, and so I didn't open those. I only examined the right hand fingernail clippings.
Okay, and so what conclusions, if any, did you form about the right hand fingernail clippings?
That there was no human DNA foreign to Elizabeth Contreras identified on the right hand fingernail clippings.
Okay. So besides that DNA analysis, all of the submitted items, and if you're gonna put in to do any other work on this case.
No, ma'am.
Pass the witness, Ron.
Morning, Ron.
Good afternoon.
See you again. Oh, thank you. So, in summary, the DNA that was found belonged mostly to Elizabeth Contreras, is that correct?
It was consistent with her, yes, sir.
Correct. And then there was some on a straw that belonged to someone named Joe Munoz.
Correct.
And there was no DNA found that you saw that was in any way associated with an individual named Guadalupe Contreras.
That is correct.
Okay. Now, we learned earlier that when they processed the car that was involved, the only surfaces that were tested for DNA were the samples where they found apparent blood. Am I correct in understanding that have you ever had DNA samples provided to you that were swabbed from like an armrest?
We have, yeah, from if they're trying to determine maybe who was touching the steering wheel or in the vehicle.
Can you get DNA from sweat? Like if it's a hot August night and I'm sitting I'm sitting in this chair and I'm sweating, and I put my arm down, would I leave, and I have on short sleeves, and I put my arm down and I get up and leave, would I leave some DNA potentially on the armrest of this chair?
It's possible that you could, and it's possible that you may not.
Okay, so in that same possibility or vein of possibilities, in an automobile, if someone was to get an automobile and there's a center console or something between the driver's and the passenger seat, in theory, if you wanted to know maybe if someone had gotten in the car and put their arm on the armrest on a hot August night, you could swab that armrest to see if potentially there might be DNA from the last occupant or an occupant of that seat, correct?
Correct. I mean, we have examined items of evidence like that, and sometimes we get a DNA profile, and sometimes we don't.
Right.
Yes, sir.
It's better to have than to not have, right?
Yeah, I mean, I would only say it. You get one chance to collect it.
You only get true. That's another good one. I'm gonna write that down. Have you ever seen a situation where they try to get DNA from like a door handle? Like if you open and close a door?
You know, we've examined items of evidence like that before.
Key fobs, that ever work?
I can't recall. I know we've worked them, but I can't recall whether we got anything from it or not. But we have received key fobs before.
But once again, you can only process the evidence that is brought to you.
That is correct. We don't collect
Your
evidence.
work is only as good as the work of those before you.
Right. We're only able to process what is collected by individuals prior to us.
That's all I have, Judge.
Announcements, witness, Ron.
All right, the rules would invoke, you know what that means?
I do, sir.
All right, if you have any items, all right, you're excused.
Thank you, Your Honor. Have a good night.
You too. All right, State, call your next witness.
Your Honor, may we approach, please?
Yes.
break. We're also going to take up a matter outside your presence. We'll let you know when we're ready.
All rise for the jury.
That's kind of good, right? In a way.
Yeah,
You may be seated.
That's how it works.
it only like showcases, you know, because if this is a neighborhood association talking about it, there's others talking about it.
You need a break, Mary?
I thought we were taking a break.
Are we going to
Are we
take?
taking a break or are we doing something outside? Yeah.
Judge, can I take my client? Let me think. We're gonna go this way.
Versus Guadalupe Contreras, present in the courtroom are attorneys for both the state, the defense, and the defendant. State, we're still in your case in chief. Were we going to have a hearing?
Nothing from the state right now, no, Your Honor. I think that we are ready to rest.
We're ready to rest.
Okay. All right.
Yes, because I don't know what
Then we're gonna have to have a recess to have an investigator go service saying that, so we're not gonna finish this week, okay? That's fine. Okay. Okay, well, when,
You could question, I mean, I just don't think we're authenticated. Like, he doesn't know how it works, and like, there's no custodian. It's been in evidence for 6 years.
that's fine, I'll take, we'll finish next week. This prosecution, he has, it says, for example, 11:01, no matter what, the clock on the video says 11:01, like you should have to do cars full. So I'm just saying, it's fine. Ready, guys? All rights for the jury? Yeah. So y'all are gonna rest, I'm gonna ask for recess to get investigated. May we seated?
All right, welcome back, members of the jury. State,
State rest, Judge.
all right, defense.
Because we need to have hearings outside of the jury.
All right, members of the jury, I'm going to give you a little exercise today. We'll let you know when we're ready.
All rights for the jury?
May be seated.
All right, defense.
I'm kind of at a loss. Before lunch, there's a surveillance video that the detective testified to about, and I asked the state about it, and we recalled the detective, and they said they were going to call him, and they said I was under the impression they brought him back, and they said they said, do you want me? They were going to call him, and they were going to offer the surveillance video, and I said yes, that would work. Now I'm told they don't want to call him, they don't want to offer him, and they're not going to let me call him and offer the video. So now I need an investigator to go serve a subpoena on the custodian of records for the business because the state has changed their position on the admissibility of their own evidence. So I'm going to have to ask for a recess to have an investigator go serve a subpoena on the custodian of records on the video that before lunch was admissible and now apparently is not. So unless we could have a hearing outside of the presence of the jury with the detective, and maybe perhaps I mean, he testified that he viewed it. He testified, that he used it, and it's referenced in his prosecution guide. I don't know, I personally don't, I understand he's not the custodian of record of the video, I understand that, but it was referred to and testified to, and its contents were referred to in the trial in front of the jury. I just wanted that actual video that he referred to in evidence. And I thought before lunch we had an agreement that that was gonna happen, but after their meeting with the witness, there's been a snafu, so that's where I stand, that's where I am.
I don't believe he testified about the video, Charles. I think it's in his prosecution guide, but I don't recall any testimony about this video, Judge. We didn't play it last trial or this trial because we never received, I mean, we didn't file a business records affidavit. We don't have a business records affidavit or proper custodian. After speaking to our witness, which is just Detective Espinosa, he's not able to lay an appropriate predicate. So the state doesn't feel as though this is something that should be admitted in the current state, Judge. It's just not, and we're not opposed to him having a hearing outside the presence to see if he can get it in somehow. But after speaking with him, I'm not confident that what's on the video is something that he could testify is accurate, or he certainly can't lay the predicate as to the functionality of or how they recorded the video, Judge. He has no idea what system they used, or if the time is accurate or anything like that.
What's on this video?
According to his report, it shows 2 cars turning on the Chive Drive at 11:01, which it does. So it supports his prosecution guide. So I don't see the concern, but nonetheless, apparently there's a concern. So
Is the officer present?
He is, Judge.
You want to have a hearing, Charles?
yes,
All right, let's bring him in. What's his name?
Espinosa, the same detective that testified last week.
Okay.
Hey, Greg, can we have them keep their voices down back there? Thank you. They're so loud, it's hard to hear.
I'll have to burn off the disc.
All right, you've already been sworn. We need to lower the microphone.
Yes, sir.
If you could just, again, introduce yourself for the record.
Detective Juan Espinosa.
All right. Charles?
Detective, in the course of your investigation, it's from reviewing your prosecution guide, you went to at the end of Chive Drive, there's a business, is that correct?
Yes, sir, there was.
And that business has surveillance, is that correct?
Yes, sir.
And that surveillance is something, according to your prosecution guide, you had a chance to review in the course of your investigation.
Yes, sir.
And as I understand it, today you had a chance to review multiple angles of that surveillance camera, is that correct?
Yes, sir.
I'm going to object to leading this question.
Okay, I'm sorry, I was trying to hurry up, Mitch, I'm sorry. Where did you go to a location at the end of Chive Drive?
Yes, sir.
What's located at the end of Chive Drive?
At the time, it was a business, oil company, I believe,
And what was the purpose of going to that location?
to look for cameras.
And did you have any luck in that search?
Yes.
And did you learn that they had one or more than one cameras at that location?
2.
Okay. And in your investigation of this case, did you have a chance at that time to view those angles of the surveillance?
Yes, sir.
Okay. And in fact, your prosecution guide reflects what you saw when you reviewed those angles. Is that correct?
That's correct.
Specifically, your prosecution guide says on or about 11:01, the 2 cars turn on the...
Could you object to leading, Judge?
All right, you can rephrase.
Do you remember what your prosecution guide says in reference to what you saw at 11:01 on the surveillance?
If I can get a copy of that, I guess.
Yes.
May I approach, I think it's marked here somewhere.
Yes.
It's going to be in an envelope that
Okay, I'm sorry.
says,
Thank you, Mary.
yeah, it says not for jury on it. There's a different envelope. There should be,
It's not offered, that one? No, that's 20. Yeah, this was,
yeah, it's for that. And it is Exhibit 49.
thank you, Mary. May I approach the witness, Judge?
Yes.
Officer, I'm going to hand you what's been previously marked as 49. I'll let you look at it, see if you can find your timeline in there. Did you find,
Oops.
you okay? Did you find anything in your prosecution guide that references you're having an opportunity to review the surveillance video?
Correct, in this
Okay.
section right here.
And does it specifically address the surveillance video you had an opportunity to see at the business that was located at the end of Chive Drive?
Yes, sir.
Okay. And specifically, is there a reference to something that happened on or about 11:01?
Yes, there is.
Okay, and whatever happened on or about 11:01, is that something you viewed on the surveillance video?
I did.
Okay. And that surveillance video you viewed at that location, was that during the course of your, at or near the course of your initial investigation?
It was.
Okay. And as I understand it today, you had a chance to review those same two videos, correct?
Yes, sir.
Now, certainly, it's not your testimony that those cameras belong to you, because they do not, correct?
They do not.
But having been out there and having a chance to view them as you did, and certainly, more importantly, you wouldn't refer to them in your prosecution guide if you didn't believe they accurately reflected the location and the scene. Is that correct?
That's correct.
Okay. So it's your belief they are of evidentiary value, correct?
Yes, sir.
And is it your belief they accurately reflect what happened the night in question on Chive Drive?
Correct.
Okay. Now, in addition to being relevant and accurately reflecting the location, you have some times, am I correct, on page 12 of 30 of States 49, you have some times listed, is that correct?
Correct.
And the times that you have listed, did you get those times from the surveillance video?
From the surveillance video.
Okay. And once again, they're not your videos and you can't vouch for the accuracy of those times, correct?
That's correct.
So if the jury, hypothetically, if the videos were to be in evidence, the jury would have to match those up with other evidence to see if in fact those cars match, like the phone records. You have the phone records.
Right.
You did that, didn't you?
Correct.
That's how you know they're the same cars, right?
Right. Yes.
Okay. And there's two different camera angles, right? One is, it kind of zooms in and out and in and out.
Correct.
And then there's a second angle that's actually much clearer.
Somewhat, yeah.
Okay. And both of those angles are on the surveillance video that you turned over to the state that they in fact turned over to me, correct?
Yes, sir.
Do you have any reason to believe those videos were altered in any way from when you gave them to the state and when you viewed them today?
No, they were not.
Judge, that's all the questions I have.
Stay.
How was it that you received these videos?
Would have been the manager that I contacted there. She was a female. The day I went, I inquired about if they had any camera system that had security. I gave them a timeline, and then I think the following day they called me and said they had a copy ready for me.
Okay, and so did you view it on their actual recording system?
I viewed the angles. I didn't view the entire sequence of events that we have.
Okay. And so, as defense counsel stated, you can't vouch for how their system operates or records, and you can't vouch for the fact that the times are correct in any way.
That's correct.
When you're referring to these times in your prosecution guide, are you referring to the camera that bounces in and out? Or are you referring to the picture that defense counsel said is more clear? Because there are two different camera angles.
There's two different camera angles, and those times are reflected based on what I'm documenting here. So the reference points of 1101, 1134, and I believe 1207, or that one camera angle.
And so the camera, I guess maybe you didn't understand my question. Are you using the camera that bounces in and out to record those times?
Both of them?
Okay. So which one is camera 2 and which one is camera 1?
So I don't remember how they were actually labeled.
Okay.
So camera 1 will probably be the one facing east, and then in the background you see maybe a refinery. It's all lit up. And then the second camera angle, it faces Chive Drive and maybe the south cornfield.
Okay.
More closer to the highway, I guess, on the right-hand side.
Okay. So the picture that's more clear, that's stationary, that's not bouncing in and out, is what camera?
Camera 1.
Okay. And you're using both of those to document
Activity.
activity?
Yeah.
Are you able to identify multiple vehicles in those?
I'm able to see two sets of headlights.
Okay. How do you know that those vehicles belong to Elizabeth Contreras and Guadalupe Contreras?
For the purpose of the investigation, I used the camera and also the data from the GPS truck, and then Elizabeth's phone data as well.
Do you see more than two sets of headlights?
In that, no. I do see traffic up and down, what's it, Corpus Christi Road. You don't see any traffic on the second camera angle, as far as I recall. But you do see traffic traveling up and down.
Pass the witness check.
So that's a lot of questions I have.
All right, thank you.
Welcome.
Sorry, Judge, I do have a question. On the camera angle that's choppy that was described to you as going in and out, is that a complete recording, or does it cut out? How does it record, you know?
So there is a bar, and then where it's red, it's recording, and where there's a void, it's probably motion sensing, so it's not recording anything. So whatever it's recording, it's something's reacting, making the camera activate, and it's recording that activity.
So would that not be a complete recording of the events that occurred that night?
If there's going to be gaps in there, and if there was like a longer gap between 10 minutes, then that wouldn't be that would just be something that wasn't recorded, or something to activate that camera to record.
Do you have personal knowledge of that being the reason it wasn't recording, or is that what your guess?
My guess and my experience of now viewing a lot of camera angles.
Okay, I'll pass it then.
That's all I have, Judge.
All right, thank you.
Thank you, Your Honor.
All right, anything else?
Judge, I'm gonna ask, I intend to call the detective and ask, I'm gonna ask him about the same questions. I intend to offer this new evidence. It's no different than any other witness who looks at a picture or a video and says this accurately reflects what I saw. And he's testified, this reflects the scene. I saw it that night. The numbers match up with the other evidence I have, so I trust the numbers so much that I put them in my report. So, and there's no evidence that there's no evidence that evidence is tampered with. There's no evidence the machines weren't working properly. So I certainly, if the state wants me to go and get the custodian, I certainly will. But I certainly don't see any evidence whatsoever that should give the state hesitation to allow this officer to allow this defense to offer the state's evidence into evidence after their own detective says, hey, I relied on this in making their case against this defendant. Because he said, hey, there's a whole page in his prosecution guide devoted to that piece of evidence. So I don't know why they're so scared of it, but that's my intent, is to call him, ask him the same questions and offer new evidence. It's no different than any other witness who's allowed to say, hey, I watched this video, it accurately reflects what the scene looked like, it hasn't been edited or tampered with. As he's told the court, he relied on it, and furthermore, he relied on his investigation. He finds the dates and the times to be consistent with the other evidence he has. In this case, like he said, GPS, cell phones, etc. So he found it to be reliable so much that he listed it he devoted the page to it. So I believe it's admissible through him, and that's what I intend to do. But obviously, I will defer to the court in its wisdom.
It's just the state's position, Judge, that the entire relevance on this video is sort of predicated on the time, and the detective can't testify that the time on the video is the actual time that it was, Judge, because he has no knowledge of how it was recorded or the recording system. I mean, counsel's well aware that that's how you get a video in that's taken by somebody else, is that you lay an appropriate predicate as to how the operating system works and that it's accurate in real time or not, Judge. And the standard isn't that there isn't evidence that it was not functioning. The standard is that there is evidence that it was functioning. So that's just the state's position, that there hasn't been an appropriate predicate laid, there is no custodian that's been offered, that it's been in evidence for years and years and years. And that's our position, Judge.
Yeah, briefly, if I'm not mistaken, early in the trial, the court cited Fowler v. State 544, Southwest 3rd 844. I'll cite the same case, which says, video recordings without audio are treated as photographs and are properly authenticated when it can be proved that the images accurately represent the scene in question, are relevant to the disputed issue, and the state, in this case, the state presented the following circumstantial evidence to authenticate the video. 1, the officer's in-person request to pull the surveillance. 2, the distinctive characteristic that there is a date and timestamp on the video. 3, the fact that the date and timestamp correspond to the date and timestamp of evidence of the case. 3, the fact that the videotape was pulled and reveals that that the evidence is consistent with the facts in the case. So in this case, there's no audio, so the video should be treated as a photograph. It can be properly authenticated that way. So citing Fowler v. State 544, Southwest 3rd 844, we ask the court to allow the defense to proceed accordingly.
I don't have anything further, Judge.
Okay, I'll give you a second. Let's super brief recess.
You've been kind enough with us, Jess. You take all the time you need. You've been working all day.
You're kind. Let the defense bring it in through that detective. Anything else?
No, Judge. Now,
Do you have it on the disc by chance?
I do.
Okay. We're ready to proceed.
All right, let's bring him in.
We have the right to this.
So interesting.
It is, right?
Mary, what number am I on?
You are on number 9.
Yeah, bars, stickers, I'm out. Shockingly, I've
How many
used
sheets have you taken?
13. Didn't you cite Fowler earlier?
Yeah. Yeah, you're good.
Like a steel trap.
To make it easy.
9?
Yeah. Thanks.
List
Hey, Judge, before they come in, just to save all the time, can I get on the record that he doesn't want to testify, then we can rest? If not, I gotta recess and do that before,
Yeah, you want to put on the
yeah,
record?
real quick, that way I don't have to bring him in and out again.
Yeah.
I'm ready.
No, I mean, Lupe, sorry.
Yeah.
That way, see what I'm saying?
Yes.
Oh, and I need to make a directed verdict motion before they come in too.
Okay.
Yeah, real quick. This is Charles Plumka here with my client, Guadalupe Contreras. Mr. Contreras, we are now ready to present our part of the evidence. In any time in a criminal trial, the defendant always has the opportunity to testify in his phase of the trial. Do you understand that? Sure. Have you and I had an opportunity to discuss your rights as a defendant in this case? Sure. Have you and I discussed the possibility of you testifying in this trial? Sure. Have I discussed with you the pros and cons of your testimony? Sure. Have you had the opportunity to ask me any questions you wanted regarding the pros and the cons of your testimony? Do you feel like I've adequately answered all of your questions regarding your testimony? Yes, sir. And after having that opportunity, have you had a chance to reflect on my answers, and have you reached a decision on whether or not you wish to testify? And can you tell us whether or not you wish to testify in your own defense? And do you feel like that decision was made intelligently, voluntarily, and knowingly? Do you feel like I've done everything you need me to do to help you make that decision? Okay, are you comfortable with that decision? Okay, thank you, Judge, that's all I have.
All right.
And then I need to make another, just outside the presence of jury.
Yes.
Y'all rested?
Yes, we've rested in front of the jury.
All right, now we're still on the record.
And Judge, at this time, on behalf of Mr. Contreras, the defense makes a motion for directed verdict. We don't believe the evidence rises to where there's a scintilla of evidence to prove the elements of the indictment, either for count 1 or for count 2. We ask the court to grant the defendant's motion for directed verdict.
State.
Do you need the state to respond?
You can.
Okay. And we understand that the defense feels they need to put that on the record to preserve, but as Your Honor knows, legal sufficiency on appeal, you don't have to make anything formal on the record to preserve that issue for appeal. That appeal, whether that is legally sufficient, can still be brought up to the court regardless of a directed verdict motion to the judge. But even if Your Honor also knows that it's just a scintilla of evidence to get over the directed verdict, and that Your Honor has heard all of the testimony, seen the GPS, seen the DNA, seen the defendant's statement, and we believe that our evidence definitely rises more than a scintilla of evidence.
All right, I'll deny the defendant's motion for directed verdict. You ready to bring in the jury?
Yes, Judge.
What you looking for?
49.
Is that the test?
His report.
Get the computer on.
All right for the jury?
May be seated.
All right, welcome back, members of the jury. This time, state's arrested, defense.
Judge, we called Detective Estimus.
All right, sir, you've been previously sworn.
Yes, sir.
Make sure everybody can hear you. Defense?
Thank you, sir. Detective, I just want to cover one thing real quickly. The incident in question happened on a street called Chive Drive, is that correct?
Correct.
And in the course of your investigation, do you have an opportunity to see if there were any businesses located on Chive Drive?
I did.
And were there?
One.
And can you tell us what type of business that was?
At the time, it was an oil company or worked in conjunction with the oil field.
Did you have an opportunity to go down and visit with anybody who worked at that business?
I did.
Were you able to ascertain or learn whether or not they had any type of surveillance or surveillance cameras in place at that business?
I did.
Did you have an opportunity to view any footage from those surveillance systems?
Yes, I did.
How many cameras did they have, if you remember?
I received 2 camera angles.
Okay. Were you able to view the camera angles while you were there on location?
I reviewed the camera angles, but not the entire footage.
Okay. At some point, were you able to review the footage that was relevant to the night in question?
Once I received a copy and back in the office.
And when I say the night in question, that was the night that later on you discovered that Elizabeth Contreras went missing, correct?
Yes, sir.
And the business that was located on Chive Drive, is that adjacent to the area you believed Elizabeth and my client, you testified, you said they met up at a cul-de-sac type of location on Chive Drive?
That's correct.
And that business is close enough to that location to where the surveillance you thought was relevant?
That's correct.
Okay. And when you reviewed the video, did you find it to be of any evidentiary value in your opinion?
Based on the time frame that I had, yes.
Okay. And now, after reviewing the video, did you believe the video accurately reflects the locations in question?
As far as the area?
Yes, sir.
Yes.
Okay. And did the cameras appear to be functioning properly?
They did.
Okay. Now, obviously, you're not the keeper of those cameras, but you talk about the time frames. Did the cameras have times on them?
They did.
And when viewing the videos, were you looking for anything in particular? Say vehicles or people or anything like that?
Correct.
And did you see anything like a vehicle?
I saw
Or several vehicles?
some vehicles.
Okay, like 2 vehicles.
Correct.
And while you can't say that you know the timestamps on the videos are correct because they're not your timestamps, did those 2 vehicles appear at a time you expected them to based on your earlier testimony about the cell phones and the GPS?
Correct, sir.
Okay. So based on that, you believe the times to be relatively accurate on the video cameras, is that correct?
Yes, correct.
Okay. Now, I've placed before you a disc that's marked Defense Exhibit Number 9.
I see it.
Okay. Now, prior to testifying this afternoon, did you have an opportunity to review that disc?
I have.
And does that disc contain the 2 surveillance videos we've spoken of this afternoon?
They do.
Okay, at this time, Judge, I'm going to offer to evidence what's been previously marked as Defense 9.
State doesn't have the objection, Judge.
It's admitted.
And that surveillance disc, that's what's referred to in your prosecution guide, which marked as States 49, is that correct?
Correct.
Okay. And specifically, it shows the 2 cars that turn in at 11:01, right?
Approximately.
That's all I have, Judge.
In addition to seeing 2 cars at 11:01, what else did you observe at 11:34?
One of the vehicles is driving away and then turning right onto Old Corpus Christi Road.
And
And then you indicated that at 12:01, let me back up. How many camera angles are there?
There's two.
2 camera angles. And so when you're saying at approximately at 11:01, you see 2 vehicles driving, which camera were you referring to?
It would be the one that's actually facing the entrance onto Chai Drive and the field that's probably north of Chai Drive.
Okay, having watched those, is it easy to see these vehicles, or can you identify the vehicles at all?
No,
Okay. And so when you say at approximately 11:34, one of the 2 vehicles is driving away, which camera angle are you referring to?
the first one, the one that we just talked about, faces entrance into Chai Drive and the field that's north of Chai Drive.
Okay, and are you able to identify what type of vehicle that is?
I am not.
And then when you indicate that at 12:01, you can see a flashlight being used near the cul-de-sac when Mr. Contreras is walking back to those cars, are you able to identify the person that's carrying the flashlight?
In that camera angle, no.
Okay, are you able to identify the shape of a flashlight?
Just a flash kind of through the field or something like that area.
So you can see some sort of a light
That's correct.
illuminated. And then when you indicate that at 12:07, the second vehicle is seen leaving, making a left turn, and you're inferring that that's when Guadalupe leaves Chive Drive ultimately, is that correct?
That's correct.
Okay, can you tell what kind of a vehicle that is?
Cannot.
Okay, can you make out any type of individual person that's driving that vehicle?
No, ma'am.
Can you see other vehicles on these camera angles?
On the first one we talked about, you can see traffic traveling north and south,
On what road?
Corpus Christi Road.
Okay, and so just so the jury knows, there's one vehicle, there's one camera angle that's stationary and one that kind of zooms in and out, isn't that correct?
Correct.
On the camera that's stationary, can you see at 11:01, 2 vehicles pulling in towards Chive Drive?
Correct.
And then is there sort of another vehicle that you see at 11:03?
Correct.
11:04, and where is that vehicle going?
Corpus Christi heading south.
Okay, so there is other traffic in the area?
That's correct.
Okay. I'll pass the witness.
Nothing further, Judge.
All right. I'm not putting the stuff on the left. You're excused.
Thank you.
Right, defense,
The defense rests.
state.
State closes, Judge.
We rest and close as well.
All right, members of the jury, what that means is that you have now heard all the evidence in this case, in this particular phase. However, you have not yet received the law through the charge of the court, nor have you heard closing arguments at counsel. Tomorrow, I'm going to ask that you be here no later than 9:30 in the morning. At that time, I will present to you and I will read you the charge of the court. The attorneys will begin closing arguments, and then I will instruct you to begin your deliberations. Now, while you deliberate, you're not going to be able to use your phones. So make sure that you communicate with anybody that you need to communicate with, that we don't know how long you're going to be without those phones. That makes sense? Obviously, if anything happens during the course of the day, then we can always figure something out. Do not observe anything online. Do not observe anything in media reports. Do not look up anything. All the information that you get in this case can only come from within the walls of this courtroom. Any questions before I let you go? Have a wonderful evening. See you tomorrow, 9:30 in the morning.
All rise for the jury.